Welcome back. A judge is weighing in over whether South Carolina Governor Henry McMaster can legally intervene in a lawsuit over voter data. A South Carolina voter named Dr. Ann Crook is suing the state election commission to block the release of data to the U.S. Department of Justice following a request earlier this year.
The DOJ wants the information of all 3.3 million registered voters in South Carolina, including full driver's license numbers and the last 4 digits of Social Security numbers. The governor has asked to intervene in this lawsuit. The Richland County judge says he will have a decision on whether the governor can intervene today. The judge will hear arguments on the case coming up tomorrow afternoon in Columbia.
All right, joining us now, our chief legal analyst, Khalif Rhodes. Khalif, can you break this down here, because you got a lot of moving parts. You have the state Supreme Court ruling one way, reverse from what the lower court says. Now the question is, can Governor Henry McMaster interject himself or not? Where do you stand on this?
I like that switching of the word intervene, interject. They're transferable in terms of what they do, but intervention is what he's attempting to do. But our favorite word is not intervention, it's injunction. So that's how we start. Man. We get to the injunction. I feel like I'm on Sesame Street right now. You know,
junction, yeah.
Right. But seriously, if you're attempting to get an injunction, you believe the 4 things: likelihood of success on the merits, irreparable harm, balancing of the equities in his public policy, and seeing where they favor. The lower court judge, circuit court in this situation in South Carolina, decided that, listen, a temporary injunction will be put in place. McMaster's, or I should say the election commission at the time, felt like that wasn't something that needed to be done, and they appealed. They appealed it to the Supreme Court, and in between that process, McMaster's wanted to intervene and get in. That means, do I have a right to be in this case? I often talk about standing. Do I have a right to sue? Well, if there's already 2 folks here, they're already playing a game of basketball, it's one-on-one. Intervention is, I want to get in this game. Yeah. I want to make it a different type of game. I have similarly situated defenses to the same folks, or I have similarly situated positions that I'm taking with plaintiff. Most of the time it's going to be a defendant. And so you have multiple ways you can intervene. You can intervene as a right to intervene, or you can have a permissive intervention. The Supreme Court ruled that McMaster's had a right to intervene, and his lawyers did great arguments. They said, listen, this underlining argument is, can my state or should my state work with and interact with the federal government? And if you don't allow me, the executive of the state, to intervene in this case, now I won't be able to have a say on how this plays out in future dealings with the federal government. I think that was a great novel argument. The Supreme Court bought it. Now the circuit court judge will see what that intervention looks like, what capacity, what level, because one side says Crook and her team, that when they attempted to file this claim, they said, all right, if you're going to let McMaster's get into this complaint, we're going to subpoena him. We want to allow, you need to allow us to talk to him. The court was like, wait, not so fast. We're going to allow him to intervene, but we're not going to give you the power to force the executive to answer questions at this moment. And I think that's what this court judge is going to address for sure.
Whether this data is ultimately shared with the DOJ or not, are there safeguards already in place for voter data protection?
And I'm not sure, and I think that's what she's asking. I mean, most of this voter information, specifically the Social Security number, is what she's not wanting to get released. And so you're saying, I don't want this to be, show me how you're going to protect it, right? If you're going to release it, because I would give 2 alternatives if I'm asking for this to happen. First, if I'm her team, and this is what they're saying, I don't want you to release it at all. But ultimately, there may be a concession. If you do release it, redact the Social Security numbers. But then that doesn't get to the end game of what the Department of Justice wants to see. They want to see, do you have Social Security numbers for all 3.3 million folks in compliance with the federal rules that have been implemented over the last 2 years? They're probably not going to be able to show that. And so then we'll be at an impasse. I think the Election Commission, if you play this all the way out, is going to come up with some memorandum of understanding. And they'll say, look, we'll want to turn this over, and we'll put safeguards in place to ensure that there is something to ensure that the plaintiff gets what she wants, to have her personal information protected. I think all 3 parties, now I should say 4 parties, will come together. There are 2 parties to the underlying claim here, the Election Commission of South Carolina and Ms. Crook, and now Governor McMaster's. But the real claim is between the Department of Justice and the South Carolina Election Commission. Those are the 2 parties that need to come together, and now these other folks are just trying to jump in.
Well, right, and so the judge ruling today on whether or not the governor can interject, intervene, whatever verb you want to use here. But do we have any precedent for governors getting into cases like this, or any other kind of legal battle?
You have folks that attempt to intervene a number of times, and yes, so there's precedent for governors to intervene when it has a connection to the role of the executive. That's why I love the argument that his attorney made. I just think that in this specific scenario, when you're dealing with elections, I think the proper folks to defend this, and that's why the claim was brought against the South Carolina Election Commission, would be those folks. They're dealing with elections. They are the people that oversee this process. They're the folks that would know where the data would be, and if they can scrub and remove Social Security information and protect it from being released, I think they are the exact party to hear it. So then the governor would have to be able to say, yes, I have a similar defense, but I'm not the same person. Because if it's similarities, too similar, the court would have rejected his intervention wholly and said, you don't even need to be here. They're already saying exactly what you're saying. He added that additional level by saying, no, because I'm the executive of this state, this will not only just affect elections, this will affect everything with our state deals with the governor, with the federal government. And I think, again, that's a great argument.
Questions of whether or not the Election Commission should be independent or supervised by the executive.
His attorney goes out and says, I'm not attempting, as he said multiple times, to Bigfoot the Election Commission. I didn't know what that meant, but I'm assuming it meant to step over them, to step on top of them. But he's saying, listen, we're not trying to do that, but we want to make sure we have our say in this fight.
All right, our chief legal analyst, Khalif Rhodes, weighing in on that for us. Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.